I'm gonna go to the first caller. The first number that called in was 650-530. 650-530.
Hey, what's going on, Mohammed? It's Jesse.
Hey Jesse, how you been?
Doing well, buddy. Thanks for asking.
Awesome.
Okay, so my first question is going to be in relation to recording documents and/or non-UCCs, more specifically the non-UCC with the Superior Court, the Clerk of Court, of like South Dakota and/or Missouri. Would that be sufficient, or would it need to go down to the county?
The non-UCC with Clerk of Court, is that where they do it in those states? Because it's usually at the recorder.
Well, in South Dakota, they have the counties and then they have the Superior Court. But given, I'm predicating this question based off of the definition of a Clerk of Court, since they're all naturalization officers.
Yeah.
Right. That's where I'm like, okay, well, I can record a non-UCC at the Superior Court versus the county.
Well, see, the county is what makes it a lien. If you do it at any other venue, it's just a notice. So you want the lien first. Now, if you already have the lien on a county level, then yeah, you can do it at a clerk of court if you want. Because if you want to go the route of using the court system as the bank, and you want to basically liquidate it through bankruptcy, then yeah, you'd be doing that. But you still need the lien first, which is always at the county level.
Got it. Which is a recorder of deeds. Yeah, that's what I was under the presumption. But since I have a couple things open throughout the different states, I just found it to be more easier, to record the non-UC at the Superior Court level. But that makes sense. You got to initiate it at the county level.
Yeah, you can just, if you want, you do initiate it. And if you want to put it at the court, then it's just going to be the whole miscellaneous stuff.
Got it. Okay, second question would be as far as warrants, right? So since warrants are created via suing the account number, right? Would this be the same process when liquidating your person's account and closing out the estate?
Yeah, because warrants are monetary instruments, naturally speaking. Since they have something called a debtor's prison, which is a system that's technically not supposed to exist, but it still does. But warrants, naturally, the way it existed, had its origin in slave catchers. And when it was issued, they would attach a monetary value to whoever was catching it. And that meaning they were just a bounty, basically. That's what it is. That's the origin of it. In modern time, they just flip that to give a more, appearance of legal aspect and hide the monetary value so they don't look like they're still engaging in bounties of slaves and whatnot. So when you do go through the court route and you actually attempt to liquidate that thing and you've done your PPN, there's actually a clause in the PPN that deals with warrants, and it's that you will invoke. And what's going to happen is, instead of one acting judge doing the order or signing the order, so your trust members will sign the order, it's called a proposed order like you would for any other court case, but it will be a warrant for the liquidation of it. Once your trust members and your treasurer, particularly treasurer and the controller, after they create it through the treasurer of the trust, because that's where the warrants will be coming from, you will now take it into that miscellaneous section of that liquidation in that court file, and it will be a panel. Because a lot of people don't know this, all courthouses actually have executive panels that's made up of the acting judges there, where they come in together as one to make certain decisions as one, rather than one make it. It's like an appeal, where it's not just one acting judge making a decision. It's going to be a yay and nay of at least 5 of them, and if 3 says yes and 2 say no, it goes through. It's like vetoing in the House. So that same process will take place if you use it in that route.
Right, and I think you kind of spoke about this in your South Dakota video in relation to the motion that you'll use to indicate, the executive committee to be able to rule on your behalf as far as liquidation.
Yeah.
Would that be correct understanding?
Yep. It's the same thing. Yep.
Got it. Okay, then my last question is in relation to initiating a foreign judgment utilizing the Secretary of State as a registered agent.
Okay, so do you already have one, or are you planning on creating one? And if so, who is it? A governmental entity or so, or is it a private entity?
Well, yeah, so the reason why I'm asking this question, or I'll give you a little context, is because, so let's say we're doing an administrative process on, like, let's say the credit bureaus, right?
Okay.
I understand that there's a difference between domestic and foreign. And I also understand that the Secretary of State has a duality to their sort of capacity, right? They're operating on the de facto side and also the de jure side. Mm-hmm. So what I'm saying is, because we're operating essentially in an international capacity with these domestic companies.
Hey, I'm inviting you to come join the patron page. Not only do you get access to documents, posts, and videos that you will never find on any other platforms, you also get instant access to webinars that otherwise will cost far more. And we speak of things that usually we would not be able to speak of on any other platforms far more freely. On top of that, you get the opportunity to send me monthly questions along with everyone else's questions, so you can see other people going through similar circumstances. You never know, what you think might be a stupid question is quite often very valid. On top of that, you get access to monthly question and answer archives from several years back from people who have gone through it and people who are going through it. Get information regarding things you experience daily that you didn't even know you could take advantage of when it comes to business, work, or other personal things. There's a community of people.
The documents you told me about, the conflict of interest, constitutional challenge, affirmative defense, and motion to dismiss. Besides those, what else did you put in?
So I put in two separate motions to dismiss. The first one was rejected. The second one I just threw in there a few weeks ago. I just did the affirmative defense and the constitutional challenge about 2 weeks ago, because that's when I first figured out about it.
Okay.
Before that, I put in, before the arraignment, the second arraignment, because the first arraignment I was in jail. They threw me in jail.
Wait, is this a traffic case? Like a traffic ticket?
I'm sorry, what was that?
This is relating to a traffic ticket?
Yeah.
Like motor vehicle stuff?
Yeah.
They're arraigning you? What are the charges? Because arraignment is criminal.
Yeah, so they are trying to charge me with intent to evade tax, driving with no insurance, driving with no license, and driving with no registration.
Okay, so that intent to evade tax, what state is that?
Minnesota.
Do you have the statute in front of you right now?
Let me take a look. I don't have it in front of me, but I can see if I could find it for you real quick.
And what are they saying regarding the intent to evade tax? Like,
they're basically stating that since I didn't register my truck and I've been traveling, that it's an intent to evade their registration tax.
Okay, I see. So it's basically tied to the registration, basically. Have you
Correct.
registered that particular vehicle before and it expired? Or is this like a new thing?
So I registered it in Colorado a few years ago and it expired, and I just never renewed it in Minnesota.
Okay, and you still carry that license plate around, or what is it? Like, do you not have a license plate on the vehicle?
Oh, I didn't have that license plate on there. I put my own private license plate on the truck.
Okay, so no plate, no insurance, evasion of registration tax. See, you're just putting in the affirmative defense. When you put in the affirmative defense, what did you entertain in it?
What did I contain in it?
Mm-hmm. What did it say?
So I purchased it from you,
okay.
And I just filled in the highlighted areas.
Mm-hmm.
I denied the instruments that the prosecuting attorney put into the file, into the case. You know, I denied all the police incident reports, the court orders, everything, and I just put it on the record, put all parties on notice.
Okay. And the constitutional challenge, you sent it to the Attorney General and chief judge, right? Of the Supreme Court.
Correct.
Okay.
Oh, not the Supreme Court. I just did the chief judge for my city that I'm in, or
Okay,
the county.
Send it to the chief judge of the Supreme Court of that state.
Okay.
So since you're newly putting in a new motion to dismiss, what, if you can recall, what was the verbiage of the motion to dismiss?
I'm sorry, could you repeat that last part? I didn't quite hear it.
If you can recall, what was the verbiage of the motion to dismiss? What was your reason for the dismissal within that motion to dismiss?
Quite a few reasons. So right when the case started, I sent out a bunch of Minnesota Data Practice Act requests, which is basically like the FOIA for Minnesota. And I found that none of the public officials involved had anti-bribery statements, foreign agents registration statements. Some of the police officers didn't record their oaths on file, the deputy city clerk. The prosecuting attorney doesn't have an oath of attorney on file. And so I predicated the motion to dismiss based off of that, based off of failure to state a claim upon which relief can be granted, no corpus delicti, no real party in interest. They didn't give me the charging instrument in the first arraignment. So I also had that in there as well.
Okay, so now hold that thought and you'll continue it also, but let me just let you know the corpus delicti is assumed to be the state of so-and-so, because if you're moving in a public space, they consider that a danger to the public if you're not insured. That's that. Two is, and I'm not saying they're right or wrong, but that's what they're saying. Two is, you mentioned,
Okay.
What was it? You said something about them not registering one thing or the other. That's kind of a gray area. That's something you should actually do a hearing on with the conflict of interest affidavit. If you were to put that into the motion to dismiss, they would not dismiss a case just because of that. Now, what you really need to do to add to the motion to dismiss as a reason to dismiss, given that that vehicle is not in a trust, is it?
No.
Okay, that makes things a little bit difficult. I'll be forthcoming with you. But what I would do if I were you now, it's probably dark over there as it is over here. You, as soon as possible, go and do a non-UCC on that vehicle's VIN number. And have the express trust be the first. Because these are the basic stuff you're supposed to do before you even go out there. When it comes to not using a driver's license and not using a license plate.
Welcome to the conference call. Please enter your access code or PIN followed by the pound sign. Sorry, the access code or PIN you entered is invalid. Welcome to the conference call. Please enter your access code or PIN followed by the pound sign. You will now enter the conference.
Okay, hey, sorry about that. I was disconnected. So you were asking about what to do when someone is recused?
Correct. Yeah. So if a judge decides to recuse themselves, or if an attorney decides to recuse themselves and switch them out with someone else, what would be a good way to go about handling that situation?
Well, the question is, how does it affect you?
How does it affect me? Well, I guess it doesn't really change anything. I guess I just have to, direct my affidavit towards someone else and essentially start some processes over again, I would assume.
Okay, so is this dealing with this same case or is it something else?
Oh, it'd be the same case.
Okay, so have they recused themselves or are you just anticipating it?
I'm just trying to anticipate it. Because I have a hearing on Monday, so I'm just trying to think of, possible scenarios that I may find myself in and kind of get prepared for that.
Okay, if they recuse themselves, it doesn't necessarily affect you negatively. It really doesn't. It's actually a good thing. Because now all the contention made by say it's an attorney, all the contentions made by the prior attorney have to now be reset by the newer ones. If an acting judge recuses him or herself, then there has to be a reason which they will state on record. So it's actually to your benefit. So I don't really see where the detriment to that will be. because that's the whole point of recusing someone. And on a note of recusing, there are two types. You can recuse an acting judge by right once without showing any cause. And then you can, after that, you can recuse by cause. It's called a show cause hearing. Those are the two types of way to recuse an acting judge. So the first time that you recuse them, you don't really say it's by right. You don't have to show a reason, so to say. The second time, you have to then show a reason. So that's how that goes. But if they recuse themselves, it's not a detriment to you.
Okay.
All right.
All right. And my last question would be, so some associates of mine, the state tax collector has been filing state tax returns on their behalf, and is garnishing paychecks and putting liens on property to get those taxes. And they said that the remedy for that is for you to just sue them. So I was wondering, what would be some things I could start gathering or having my associates gather to initiate a lawsuit?
So they've been
kind of
filing taxes on their behalf?
Yes.
What type of entity is this?
So
State agency or a private entity?
It's not any agency or anything like that. It's just them themselves. Like if they don't file like a state tax return within a certain time period, the state will just file it on their behalf and then turn around and garnish their paychecks or put liens on their property.
That's the first time I've ever heard of that. Are you sure so the state of so-and-so is the one filing the taxes on their behalf? Is that what's really happening?
Correct. Yep.
And is it state taxes or federal taxes?
It's a state tax.
So it's state tax. Which state is that? So-and-so is basically filing on his or her behalf and then garnishing just because of that. Then that employer has a lot to do with that equation, without a doubt. So there's something in that equation that's missing that either he or she doesn't know. They must find out. For all of them, they can get access to their files. When they work, you just start reading it and you'll see it there.
Okay, perfect.
Right.
Well, I'll pass that along. I appreciate the time.
All right, take care. Okay, this is the last number I'll be answering. It's 267-266. 267-266.
How you doing, Mr. Muhammad?
Hey, I'm Dallas. How you been?
All right. I only have one question. This question was based off of the service I acquired for the 9A number. So I was looking at the start date, and I was wondering if the start date, because it was in 2019, would it conflict with the paperwork of the date of the paperwork when it was created in 2023?
No, it would not, because you can start a business before putting it on paper.
Okay, that was really the only thing.
Yeah.
And the thing that you mentioned earlier was called M-Bank. The M-Bank with all the judges, that's the executive board that you're talking about?